Carolina. Mr. Gowdy.
Thank you, Mr. Chairman. Good afternoon, Ms. Ingram. What is the legal authority by which a President can sui sponte decide to enforce or not enforce certain provisions of a law?
I'm not in the group of people who analyze the legal underpinnings of that, but it is, I will say as an administrator, it is not uncommon when there are large new, particularly information reporting related things.
I'm actually asking for the legal basis. Can you cite a case?
I'm probably the wrong person. I understand.
Well, you're an attorney.
There has been, but I have not done the analysis in these cases.
Well,
let's
simplify the analysis. Can a President unilaterally increase a fine that Congress set?
I'm sorry, I'm confused by
It's not a trick question. Can any chief executive unilaterally increase a fine or a statutory maximum?
I don't know of any example of that.
So the answer would be no.
I hesitate to respond for all of the agencies and all of the statutes on the book.
Just despite the fact that I'm a lawyer too, I'm going to say, trust me, the answer to that question is no. You can't. You can't decide that we think the maximum for burglary should be life instead of 30 years, so we're going to sentence somebody to 40 years. You can't do that.
I understand, sir.
All right. And you would also agree a President cannot unilaterally suspend a mandatory minimum. If the law says you have to spend 5 years in prison for a 924C violation, a President can't just decide he doesn't like that law and suspend it, correct?
Again,
it's not a trick question. It's not even a legal question. It's more of a civics question.
I'm trying to get my head around the parameters of the
Mr.
question,
Gowdy,
sir.
Mr. Gowdy, would you let a layperson intersect for a moment?
If the gentleman would be gracious enough to toll my time.
I'll do my best.
Thank you.
As a layperson,
Yes, thank you.
in your 31 years at the IRS, have you ever looked at the letter of the law on which you are executing IRS requirements and then seen an executive order that is inconsistent with that and gone with the executive order? In other words, do you ever consider as a lawyer and as a 31-year professional that the President can usurp IRS law or regulation through executive order? I didn't say fill in the gaps. I said usurp, go contravene existing law.
Would the Chairman indulge me in taking that in two parts?
That would be the gentleman from South Carolina's decision.
My time's being told.
Not anymore. I'm done.
Well,
may I respond?
You may.
Thank you. The executive order President part, I don't understand in the question, but let me put that aside. I will say it is not uncommon in my 31 years, particularly when a statute is new or particularly when the constituency is having logistical, operational problems meeting their obligation under a statute, that the IRS has given people either additional time, an additional year, or tried to tailor on a temporary basis what people have to do with that statute.
And my question is, what is the legal basis for that? What is the legal basis? Have you ever seen an instance when an executive unilaterally increased the marginal tax rate?
No. Increase? No.
So you will agree that there are certain categories where the executive can't change the law, even if the executive may not agree with the law.
It's never a question of whether we agree with the law. The law, that's not relevant to the decision. The question is, and it's particularly in the information reporting area, that
I'm not talking about information reporting. I'm talking about a statute passed by Congress, and I want the legal authority by which an executive can decide which portions of that law he or she wants to enforce and which provisions of that law that executive sui sponte decides not to enforce.
If there is any variation from the bare letter of the statute, it is never a single person, and it always includes legal analysis by someone, not me.
Well, the most recent legal analysis from the Department of Justice is only if an executive believes that a law is unconstitutional, i.e. DOMA, can he or she refuse to enforce it? I want to read an exchange to you back when the President from time to time did get difficult questions from the media. So we're going to go back a while, but I want to read an exchange where he was asked this question. People question your legal and constitutional authority to delay the employer mandate. Did you consult with your lawyer? And this was the President's response. If you heard me on stage today, what I said was I will seize any opportunity I can to work with Congress to strengthen the middle class, improve their prospects, improve their security, but where Congress is unwilling to act, I will take whatever administrative steps I can in order to do right by the American people. I did not hear a legal authority for suspending the law. I heard a political justification. Did you hear a legal authority in his response?
I don't know anything about his response, sir.
Well, I just read it to you. Did you hear a legal justification for suspending certain provisions of the law?
I only heard what you read. It speaks for itself. I can't really interpret it.
Can you cite me a legal justification for determining which portions of a law you want to summarily turn off and turn on?
I'm not familiar with anything in the way that we administer the tax code where we would be changing things in the way that you previously mentioned, changing a tax rate, increasing a tax amount, reducing a tax amount. The situations in which I've been involved, both in ACA and prior to ACA over the years, have had to do with taking into account requests from the community who need more time or more logistical help in meeting their obligations under the
So your testimony is there is no provision of the ACA which was passed by Congress that is not being implemented precisely as it was passed by Congress. Is that your testimony?
as we understand it to be passed by Congress.
What does that mean, as we understand it?
I respect.
Have you failed to meet any deadlines? Has any portion of the ACA as passed not been implemented on the timetable under which it was passed?
The gentleman's time has expired. The gentlelady may answer.
Thank you, Chairman. There are several provisions where, at the request of the taxpayer community, we have taken into account their need to have a delayed phase-in of provisions passed by Congress. I would point you to the W-2 provisions, which were logistical administrability requests from the community, and the information filing requirements for employers and insurers were based on extensive and persuasive requests from them that they needed more time to arrange their data and build their systems. The actual employer tax can't be figured out without some of that reporting.
Mr. Chairman, I would ask unanimous consent to ask just one more question because something in her response prompted another question.
Without objection, so ordered.
You said you had heard from the taxpayer community. I'm not familiar with that entity in our tripartite branch of government. How about Congress? My question is, what is the role of Congress when the executive decides he or she wants to sui sponte, not enforce a provision of law heretofore passed? Not the taxpayer community. What's the role of Congress?
Congress, from time to time, will enact statutes with due respect to this body that the community tells us are difficult to administer on that exact time frame. We try to listen to the community. We do not always do what they ask, but where it's reasonable to us and we think that it's a temporary accommodation and does not do lasting damage to the actual enactment of Congress and the ongoing implementation and phase-in of the law, we will take their views into consideration. And we take very seriously our obligation to listen to that community as part of our job.
Mr. Chairman, I'm out of time. I just find it stunning. I literally found that answer stunning, and it's hard to stun me that an executive branch entity would not enforce the law because some constituency group decided it was hard to implement it. That is not the way this works. Either Congress changes it or you live with the consequences of it. But can you imagine the community just deciding they didn't like some other provision of our criminal code being enforced? Can you imagine that, Mr. Chairman? I just found that response to be stunning, but I'm out of time.
Mr. Gowdy, you are out of time, and I guess one of the problems is that unions, large companies are a community, and the individual taxpayers apparently not getting a delay when they can't even get on the website are not a community. With that, we go to the gentlelady from Illinois, Ms. Duckworth.
Thank you, Mr. Chairman. I have grave concerns about the data sharing network that was created by the Department of Health and Human Services that just became operational a few days ago. Ms. Ingram, I understand that you don't run this data sharing network and that its head does not report to you. Is that correct?
That's right.
Thank you. I wish that we had those folks here so we could actually ask them some questions about how that program is running. With that, I yield my time to the ranking member.
Thank you very much. I was just listening to your exchange with Mr. Gowdy, and I guess I hear all the complaints about IRS, and I remember when I practiced law. One time I was audited for 5 years in a row. I mean, at one time, and it was.
The gentleman was suspended for a second. I ask unanimous consent that the remaining time be fully yielded to the gentleman. You are now recognized for remaining time.
Very well.
She can't actually yield and then leave under the rules,
Oh,
so it's
thank
now
you.
it's your time.
Thank you very much, Mr. Chairman. And I represented a number of people, and when they got a notice of audit from IRS, or they got certain letters from IRS, they would get very upset and very nervous. And I was listening to what you just said, and it sounds like you're talking about a situation where sometimes there can be an IRS that may try to work with folk, the community as you call them, to show some consideration. Is that what you're trying to say? I mean,
Yeah, I'm trying to distinguish between whether somebody likes or doesn't like a law, which is irrelevant to our work, but whether there are logistical, practical problems with people's ability to do the mechanics of what they need to do. And I just would like to distinguish those 2 points.
yeah. I guess sometimes you're damned if you do and damned if you don't. We've heard a lot about IRS, and certainly we've had some bad actors. And, and I know that members have applauded you for what you've done, but, the word on the street is that you're a superstar. Now, I know you don't have to shake your head. I'm telling you what I heard. And that they get you to take on the tough assignments. Did you ask for this one?
No, sir, I did not.
And the reason why I mention this is because, the more, as I listen, I was saying to myself, it sounds like IRS has put it, the piece that you have, you've been able to put it together. And can you kind of tell us about how that came about? In other words, I guess you had timelines, and were you constantly hitting those timelines? And, because there are some other problems in some other areas, maybe some people need to listen to how IRS did this. And I'm not trying to put you on the spot. In my office, I constantly say 2 words: effectiveness and efficiency. I tell them we have one life to live. It's a limited amount of time on this earth. We've got a limited amount of time where we are. We got to get things done. We got to get them done well. So I'm just curious. Can you talk about the process of getting to where you've gotten to?
I think a very basic part of our success to date and our confidence in our planning going forward is that we recognized that we needed talent from across the IRS, and we identified that talent. We set up a governing committee that's chaired by the 2 deputy commissioners, and to which we all report in. And if somebody wants more detail about that, there are a couple of GAO reports from 2011, 2012 that go into that in more detail. But we tried to set up very early on the best governing mechanism and project management mechanisms that we could to ensure that the various phased implementation implementation of the various phases of the ACA, depending on effective dates and when it would hit tax administration, could be well organized, scheduled, and simultaneously worked on in parallel paths. And I think personally that our effort to get that organized well has meant everything about our collective ability as a team to be ready for October 1st and for our confidence going forward towards the 2015 filing season.
And just one other question. These furloughs, how does that affect, I mean, we're talking the subject matter of this hearing is, where we are with regard to IRS and your relationship to all this. How does these furloughs, if at all, affect the things that you're doing, the process with regard under your shop? I'm just curious.
Well, what we've paid attention to is the need to have our computer systems be operational on 10/1, and the minimum number of people needed to either operate them or from my shop, business people, in order to support that work. So there is a small number of people from my shop who have been on duty to support the operations of the IT portion.
Thank you very much, Chairman.
Thank the gentleman. Because we can never tell how many members are going to come and go, and we have up to 10 additional members who may ask between both sides, Ms. Ingram, would it be appropriate to take about a 5-minute break?
I'm happy to, yeah.
Why don't we go ahead and do that, just so that we not take you in a, because I can't tell you how much longer beyond the people sitting here. So we'll stand in recess for just a few minutes. Okay, if everyone could start taking their seats. Committee will come back to order, and we'll now go to the gentleman of Texas who's been patiently waiting. Gentleman, Mr. Farenthold is recognized.
Thank you, Mr. Chairman, and Ms. Ingram, I appreciate your being here. I know that is not the most comfortable seat to be in Washington, D.C. I want to kind of step back and take a 30,000-foot view of what's going on right now. Now, when people think about the IRS, and I would imagine your primary responsibility is to collect taxes, the bulk of which is income tax. Is that correct?
That's the primary purpose, yes.
And the IRS relies on people to voluntarily comply with the income tax law. Sure, we have the audits here and there, but the vast majority of what the IRS does is based on the public complying with the laws, correct?
Yes, it's a cornerstone of our democracy.
Now, with the current scandals that are going on, it's my feeling that the American public is losing confidence in the government. You had some of the leaks within the IRS with respect to member lists of organizations. You had the whole targeting scandal. Do you think these miscues, and I'm trying to pick a benign word here, have a negative impact on how the Americans perceive the entire government and the IRS in particular?
Without speaking to particular examples, I am deeply saddened as a veteran of the civil service at anything that damages the confidence of the American people in tax administration.
And would you agree it's inappropriate for the IRS to share information with anybody for political purposes? And would you agree with that?
I don't think political purposes should ever be part of our work.
And in fact, that was one of the articles of impeachment against President Nixon. It eventually led to his resignation. Was a charge that he was improperly using that information. Let me go to. So I think we've got a problem here that needs to be addressed in a big picture way. I also want to talk for a second about data security. As a former computer consultant, I know no matter how good a job you do at securing your own network, once you open up a hole for somebody else to get in and share data with them, you can no longer really have control over the ultimate security there. So assuming the IRS were perfect in this age, I don't think there's such a thing as perfect cybersecurity. But as you start sharing personally identifiable information, including potential medical information with third parties, is there anything in place to where if somebody's not being careful with that, you can cut them off? I mean, how do you deal with the security from your third-party folks that you're sharing data with?
I think there are a couple of pieces to keep in mind about the situation. One is I think we'd be glad to provide a more detailed briefing later on the whole data security at the IRS piece, and I think that could be arranged.
And that's something I would like to do. But you do agree that as more people have access to the information, the more difficult security gets.
Which is why in the arrangement of how we were going to share data in this instance, we insisted that the data not be displayed outside of the machine to individuals looking at a screen or the people helping them.
All right, and then I want to get to something the ranking member said. He was talking about the government shutdown, and you mentioned you furloughed quite a few people in yours. My understanding is the reports are 91% of the IRS has been furloughed. Does that sound right to you?
I'm not an expert on the details. It sounds roughly right.
And my understanding, again, is that the people who take the checks and cash them for people who will be filing on the last minute, October 5th, are there, but the people who process the refunds for the people who are owed them are not. Are you aware of that?
I'm not an expert on the criteria for which people stay or not, but there is a life and property aspect to that.
I appreciate it. And I promised Mr. Gowdy I would give him my last minute because he didn't get everything. So I'll yield to Mr. Gowdy, and thank you very much.
Thank the gentleman from Texas. Ms. Ingram, we're told from time to time on this side of the aisle that the Affordable Care Act is the law of the land. It's been affirmed by the Supreme Court, and that we ought to just get used to it. You may, from time to time, have seen some of my colleagues on the other side of the aisle sharing that sentiment with us. I want to read another quote to you, and this is not from you, so I'm not going to ask you when you said it, but the quote's important, I think. Everyone is up in arms because they don't like it. They can't do anything about it. They want the IRS to fix the problem. So everybody is screaming at us right now, fix it before the election. Do you know who said that?
I have no idea, sir.
Lois Lerner said that before she invoked her Fifth Amendment privilege, and she said it in connection with Citizens United. The President's been very vocal himself in calling for the overturning of Citizens United. So in conclusion, I guess some of our frustration is this. The President doesn't like Citizens United. Lois Lerner doesn't like Citizens United. My colleagues on the other side of the aisle don't like Citizens United, so they can advocate for its repeal and its legislative remedy and not following it, and they're not called arsonists or terrorists or anything else. But those of us who may think the Affordable Care Act is costing people jobs or may be offended that the HHS would mandate people violate their religious views, somehow the analysis is different when we ask that a law be changed or repealed or not enforced. So the duplicity of that, of Citizens United versus the Affordable Care Act, I think is what's fueling some of the frustration. And with that, I would yield back.
And I thank the gentleman. We now go to the gentlelady from Illinois, Ms. Kelly. I think your mic, please.
Thank you, Mr. Chair, and thank you, Ms. Ingram, for being here today. I would like to ask you about the allegations that have been lodged against you. Republican Congressman Tom Price accused you of systematic harassment of conservative and religious organizations. He also argued that your employment at the IRS should be suspended. I would like to give you an opportunity to respond to those comments directly, because congressmen and women can say a lot of things to the press and smear your name and never give you a chance to respond. Did you engage in systematic harassment of conservative and religious organizations?
No, ma'am.
Throughout your 31-plus-year career at the IRS, have you ever treated a taxpayer differently based on your own political or personal beliefs?
Absolutely not.
And I want to again talk about the timeline. I know we've discussed your move from the Commissioner of Tax-Exempt and Government Entities to your new position at the ACA in December 2010. Is that correct?
I'm sorry.
You
I was
moved-
distracted by the sign. If you could ask me again.
That you moved from the Commissioner of Tax-Exempt Government Entities to your new ACA position in December 2010. Is that
Yes, ma'am.
correct? And during your transcribed interview with committee staff, you said that during your tenure as Commissioner, Ms. Lerner never told you about the allegations related to the Tea Party cases.
I have no memory of hearing about them while I was there.
And you became aware of the general allegations in 2012 really from press releases. Is that correct?
I heard some things in the press, which is, I heard that, and then in the spring, my boss asked me to sit in on a couple of meetings he had called.
So that Deputy IRS Commissioner Stephen Miller
Mr. Miller, yes.
right, asked you to attend a meeting about the allegations in 2012.
Yes, in the spring.
And that's when he decided to send the team to Cincinnati to conduct an internal review of what happened. Is that right?
Yes, that was what I was observing going on when I sat in on the meeting.
And were you on that team?
No, ma'am.
Did you conduct any internal review?
No, I had no role in between the few meetings I attended other than to help persuade Ms. Marks to participate in the team.
Okay. But when the review was completed, you were informed by the internal review team that some applications for tax-exempt status had been screened using inappropriate criteria and experienced delays.
Mr. Miller asked me to sit in on a meeting where they reported back, and I heard at that time that there were serious concerns based on their on-the-ground review about the delays in cases, the handling of cases, the filter criteria for organizing inventory.
Were you involved in any way in the action plan to address these problems? Were you involved in any way?
I sat in on a couple of meetings that Mr. Miller asked me to join that at which the team presented their proposal of what they would recommend happen next in terms of analyzing and moving cases, educating staff, and so forth. So I sat in on some of those meetings, and that was kind of my role.
Okay. But you weren't a part of developing or overseeing or implementing?
No, I neither developed nor supervised the execution.
And why do you think you weren't a part of it?
Because I had a more than full-time job. I know many people in this room work long hours, but 60 or 70 hours seems like a full-time job to me. And that job was ACA, and I was not having any of my ACA duties taken off me. So when I could sit in, when I was requested, I tried to cooperate, but it was only a few times, and I didn't make a lot of the times I was invited.
Okay. And did you play any role in Lois Lerner's decision to reveal the IG's findings at the ABA meeting?
None.
Okay. So let me just see if I have this right. You were not responsible for conducting the internal review. You were not charged with implementing the corrective measures, and you had no interaction with Lois Lerner about her decision to discuss the allegations at the ABA meeting.
Correct.
Thank you very much. I yield back.
Thank the gentlelady. We now go to the gentleman from North Carolina, Mr. Meadows. Could you yield me just 30 seconds?
I'll be glad to, Mr.
I just want to make sure I follow up on Ms. Kelly. Let's understand this. For the first 10 months of the targeting of conservative groups, you were there and it was your job between February and December of 2012. And then until May of 2013, you held the title, meaning that you had a responsibility even if you were doing another full-time job. So for 10 months, you were Lois Lerner's boss and in residence. For the next 2 years, you were Lois Lerner's boss, but not in residence. But still, ultimately, if she or people were doing something wrong, it was still something that you should have either relinquished the title or taken some action. And in May of 2012, when you knew that, having regularly come up here, you never informed Congress of the targeting even after you described it. I just want to make sure that Ms. Kelly's statement that you were somehow not part of it be understood, that for 10 months you owned it as the boss. For the next 2 years, you owned it by title and did not relinquish the title. And for a period of time after you discovered the scandal, you did not reveal it. And I find that concerning.
Mr. Chairman, I ask unanimous consent that the gentleman be given an additional 3 minutes and she be allowed to answer the allegations that you just made against her.
These are not allegations. These are
Well,
facts.
why don't you let her answer
These are the dates.
I object.
You object to a lady defending herself?
The gentleman.
I mean, you guys are sitting here making allegations against this lady, a 31-year employee. You make these allegations and then you won't even let her answer it. That's not right.
The gentleman will suspend. The gentleman, you asked for unanimous consent because of a statement that there had been allegations. I stated a chronology of facts. The chronology of facts are, for 10 months, she was on the job during the period of this scandal. Additionally, for the next several years, she had the title but was not in residence, and she, by her own testimony, testified that she became aware of it, however, did not inform the Congress or take measures to make it public, and it became public through other means. None of that is in controversy, nor is it an allegation.
Well, she was sitting here shaking her head, and I just wanted her to have an opportunity to say whatever she was thinking. Maybe she doesn't have anything to say, but the whole time she's shaking her head like this, and I'm just trying to be fair to the witness. That's all I'm asking. I want the truth, the whole truth, and nothing but the truth. So help me God.
I'm sure you want the truth if, in fact, it vindicates somebody who, for 10 months.
It's not about vindicating. It's about allowing someone, when you make allegations like that, when you make allegations, a person should have an opportunity to defend themselves. That's why I asked unanimous consent that he be given more time and that she simply have an opportunity to respond. Now, if she does not want to respond, fine.
Well, I thank the gentleman. Would the gentleman please suspend? Reset it to 5 minutes. If the gentlelady would like to respond as to the chronology, particularly as to the first 10 months in which you were on the job while conservative groups were being targeted, that's fine. I'd be happy to have it. I was responding to Ms. Kelly's essential statement that, well, you didn't, when in fact the timeline is different. It's not the subject of today's hearing, but if you have some further input, we'd certainly be glad to hear it.
Well, with your indulgence, Mr. Chairman, I just would like to put a few points on the record, one of which is during the 10 months that I was, more than 10 months, during the 2010 year before I went to ACA, at TEGE, I had 5 discrete areas that I was responsible for, and a lot of very big things going on, including EEO, that had nothing to do with the determination letter program as it relates to 501c4s. I have no recollection of hearing about the incidents that are contained in the TIGTA report. We were very busy with some issues that affected tens of thousands of exempt organizations, such as the statutory requirement that after 3 years of non-filing, organizations become non-qualified. That was taking a lot of time. We were working on the implementation of the charitable hospital rules that the ACA imposed on the charitable hospital sector. That was a great deal of work. There were a lot of other things going on, and I just want to put that in context for 2010. When I was assigned to go to the ACA, in the same announcement, the Commissioner announced an acting Commissioner in charge in my absence. And it was made quite clear to me that my responsibilities laid at the ACA project. And since that was a more than full-time job, and there were people in charge of operating the TEGE division, that is where I was told to concentrate, and I did. From time to time, where, because of my previous experience, such as in Indian tribal governments, I could be helpful by very briefly helping out with a particular task, I was asked to do that. It was always on top of my ACA duties. So if you talk about 60 or 70 hours when I had to do that, it was on top of that. In the spring of 2012, the few meetings I was asked to sit in on, I saw in those meetings people, including my own boss, who were focused on the issues that they were learning about, upset about what they were hearing, wanting to get to the bottom of it, wanting to make sure they understood what was going on, and I assured myself that TIGTA had become involved. And knowing that that team was in charge of it and driving it, and having very clear instructions that my job was ACA, and knowing that TIGTA was in the mix, who I trust to get to the bottom of these kinds of questions or allegations of this nature, I continued to work on ACA. So although I understand that the fact that my title on paper was not changed for some time, and despite the fact that I repeatedly offered to my bosses, put me wherever you need me to be to do the work I come in every day to do as an impartial civil servant, the fact that the title did not change, I understand sometimes confuses people, but I would like people to understand the nature of what my responsibilities were and my knowledge were at those various periods.
Well, I appreciate that.
Thank you for the opportunity.
And I appreciate that, and hopefully you appreciate that what you said, and I take it as completely accurate, 100%, is not inconsistent with the 3 statements I made, that you were in charge for the first 10 months in which this scandal was going on without your knowledge, that you had the title for the next 2 years, that you became aware of it, and by your own statement, you felt that TIGTA was taking care of it, so you felt no responsibility to inform Congress or in any other way go public with it. I'm not faulting you. I'm saying you didn't know what was going on while this bad service was going on for the beginning of it. You maintained the title. That's not a disparagement of you. The fact that you said maybe somebody else should get the title, in fact, probably is part of the challenge, is that an acting should have been a confirmed, if you will, individual, so that you would get past the question of somebody handling this. And then, of course, lastly, while many people at the IRS knew about this well before the election, as it was being asserted, it was kept private. Not blaming you, but as Ms. Kelly was going through her series, I saw these 3 timelines that I thought I could accurately state, and I believe I did. I think you've accurately confirmed, through no fault of yours, that these were accurate timelines, and that part of what is an investigation of this committee is, in fact, all the various elements that went into people at 501c4s, disproportionately conservative groups, from before 2010 until today. Many of them have not received an approval or a denial. And that's what I think some members of Congress have called bad customer service. I wouldn't call it bad customer service. I have other terms for it, but hopefully we've settled that. Mr. Meadows, I appreciate your patience. You're recognized for the full 5 minutes.
Thank you, Mr. Chairman. I do want to give you a chance, because earlier in the testimony, Mr. Cartwright was asking a question. You responded, and I think you misspoke briefly, because his question was, were you employed during the time in that particular position while targeting was going on? And your answer was no. And I believe that we know from the timeline that was just shared that indeed you were there for at least 8 to 10 months while the targeting was going on, according to what has been reported with the Tigna report. Is that correct?
May I state that I have not studied the Tigna report?
I have. I've read it probably 5 times.
I respect that, sir. So,
assuming that the Tigna report is correct and the targeting began in February to April of 2010, were you indeed employed in direct management capacity at that particular time?
If that's the time frame that you're using.
That's what they report, yeah.
Okay, then I was
because in that
formally and functionally the commissioner until December.
Okay, because in that report, they gave a chart
Okay.
that was not just a chart in name only. It actually, that's where I first learned of your name, was from the Tigna report.
Okay.
And so in doing that, they put in that there was systemic management failures or lack of management that would directly implicate you. And so so today, you are correcting your testimony. You were there during that first part of 2010 while targeting was going on.
If that's the period you're talking about, I was at TEGE as commissioner, yes.
Okay. Were you upset that Lois Lerner, prior to your meeting that you were brought back in with Mr. Miller, were you upset that she never told you about any of this targeting? Because she was right in the middle of the storm. You had a personal relationship, not just a professional relationship. Were you not upset that she didn't share any of this?
So once I was on ACA, I wouldn't have been necessarily a logical person for her to turn to.
But it
known,
happened under your watch, so you wouldn't be upset with her that she didn't share it with you.
If I may finish, sir. I wish I had known information during 2010 that I could have helped deal with that in a better way. But I don't recall ever knowing about the kind of stuff that I understand the Tigna report covers. And after I went to ACA, I would not have been the right person. So what did you know?
You say the kind of stuff. So what did you know about during that period of time? Those are carefully chosen words.
No, sir. I'm sorry. They weren't particularly carefully chosen. I apologize. I was aware that there was a lot of noise out in the public about the Citizens United case. I was aware that there were a lot of other critical EO projects that affected lots and lots of EOs, and some of which had mandatory implementation dates from the legislation. And I know that traditionally, the kinds of cases in which questions would arise about political activity or campaign intervention had come up in the C3 area and had come up in the exam stream and the process for selecting cases for exam based on letters that members of the public write to us all the time, suggesting that we look at their opponents.
So let me ask you this. If you were called to testify back then, would you have given the same statement that you have today with regards to the implementation of ACA, that everything is good, it's copacetic, everything is going along the way it should? Because obviously, I guess you were under that belief then. So could you be wrong today as you were wrong in assuming that everything was going well under your previous management?
The oversight of the division involves a different management process and set of reporting up and division of labor than a project management office does. In a project management,
so you're definitely sure you're right today, and that's because your role has changed.
Because in a project management office, my role is very hands-on because of the structure and nature of the project.
Okay.
I have more
personal
knowledge.
All right, well, let me ask you then, with Obamacare and the data hubs, I know a lot of that is HHS. are you involved in the nature of their testing from a security standpoint on going back and forth? Is the IRS involved in that, or is it all on the HHS side of things?
My understanding is that our testing with them is as to their connection, the handshake between their machine and our machine, to make sure that the handshake works. We're not involved in the testing they do with others.
I'm out of time. I yield back. Thank you, Mr. Chairman.
I thank the gentleman. We now go to the gentleman from Massachusetts, Mr. Lynch.
Thank you, Mr. Chairman. I want to thank the ranking member as well. I just have one matter that I want to just address. A number of speakers ago, one of the gentlemen from the other side suggested that it was comparable what the Republicans were doing in attacking the Affordable Care Act to the President's opposition and Democratic opposition to the Citizens United decision. And it is true that the President and many Democrats, including myself, have called for the repeal or the overturning of the Citizens United decision. However, importantly, I think it is important to say that neither the President nor I have shut down the government in pursuit of our goals. And neither the President nor Democrats in Congress have suggested that we default on the national debt in pursuit of our goals. And I think that's an important distinction that has to be made. Ms. Ingram, thank you very much for your willingness to come before this committee and help us with our work, and I appreciate your patience. I do have some questions regarding the role of the IRS's Privacy, Governmental Liaison, and Disclosure Office in your role in implementing the ACA. Ranking Member Cummings earlier requested that a representative from this office appear as a witness today. However, that has not happened. The Chairman refused that request, and so I'll direct these questions to you. According to the IRS organizational chart that I'm reading, the Office of Safeguards has the responsibility for monitoring nearly 300 Federal and State agencies that currently are permitted to receive taxpayer data to ensure that they are complying with privacy laws. Under the Affordable Care Act, the IRS, HHS, State and Federal exchanges, and other Federal agencies will share taxpayer information in order to determine an individual's eligibility for the premium tax credits. Ms. Ingram, is the sharing of Federal taxpayer information with State and Federal agencies a new task for the Office of Safeguards?
Well, for a more complete answer, we can provide that through that office, but we have decades of experience with the sharing of tax data under the long list of exceptions to 6103 that Congress has from time to time added to that section. This is a new one, and we've taken the same kind of care, if not more, in making sure that the safeguards are in place and that our oversight is launched.
Very good. So it sounds like this office has a longstanding experience in overseeing the transmission of taxpayer data?
Yes, sir.
Okay. And what kind of policies and procedures must State and Federal agencies have in place in order to receive taxpayer information? Could you describe that?
So I'm going to give you a high-level answer because I am not an expert on the details of it. For example, the Oversight Board document, those pages were prepared by the Disclosure Office. But in general, there are very detailed there's a very detailed publication, Pub 1075, that sits on our website. There's an extensive multi-page template that is the foundation for the Safeguards Procedures Report. There are also a number of other kinds of data sharing agreements under various statutes. Those have all been implemented with the appropriate entity, whether that entity, as I said in my testimony, is HHS or whether the entity is the ultimate recipient of the data.
Okay. Now, these Federal agencies and State agencies, do they have to go through a certification process in order to receive this information?
Yes. We do not release any data to anybody that we're not comfortable that they have sufficient safeguards in place following all the detailed procedures in those requirements.
Okay, and were the State and Federal aid exchanges certified pursuant to this process prior to October 1st?
Yes, the Data Hub, the federally facilitated exchange, the individual exchanges at the State level, and several of the Medicaid offices had also asked to be certified by October 1st.
Okay. Well, my time is short. I do want to thank you for your service, and I appreciate you coming to this committee and helping us. Thank you. I yield back.
I thank the gentleman. We now go to the gentleman from Michigan for 5 minutes, Mr. Benfield.
Mr. Chairman, thank you for holding this important hearing today. Since I came to Congress, I have heard from every sector of the economy, and they all tell me the same thing. Obamacare is making it difficult to create more jobs and making it more costly to buy insurance. From the city manager of Plymouth, Michigan, who told my staff that he's unsure if the city parks can be maintained because it might put the city over 50 employees, to nearly every single business owner who comes into my office worried about the insurance they currently provide their employees skyrocketing in price. Obamacare is hurting a lot more people than appear to be helped by it. At this time, Mr. Chairman, I'd like to enter for the record, if I may, today's Washington Post, a particular article, many foresaw health site jam.
Without objection, so ordered.
Thank you. It says, basically, 2 allies of the administration, both of whom spoke on the condition of being anonymous because of the controversy surrounding the rollout, said they approached White House officials this year to raise concerns that the Federal exchange was not ready to launch. In both cases, Obama officials assured them there was no cause for alarm. Outside the White House, people familiar with the setup efforts had been warning of chaos in the days and months leading up to October 1st. On September 18th, Louisiana's Health and Hospital Secretary Kathy, if I get this right, Kleibert, testified before Mr. Langford's subcommittee that the administration was giving confusing information and making last-minute changes that left the State scrambling. John Ingates, Chief Technology Officer at service provider Rackspace, said the government should have been able to prepare for the type of traffic that the site has experienced. I think that any modern web company would be well prepared for a launch at this scale, said Ingates. We're not talking about hundreds of millions of people, and we're not talking about complex transactions. This isn't downloading full movies off of Netflix. The question I have is, did they have enough time to prepare, and did the people doing the work know what they were doing, in the quote in the newspapers? My question today, your testimony today, Ms. Ingram, sounds like testimony this committee heard earlier this year from CMS Administrator Marilyn Taverner and Director of the Center for Consumer Information and Insurance Oversight, Gary Cohen, that everything was fine and that the administration would be prepared for October 1st. We now know that the administration was not prepared for October 1st. How can we know that the IRS is adequately prepared and that there was enough time for IRS to conduct the checks and make sure the safeguards were in place to protect all the sensitive information flowing through Obamacare Data Hub?
So I think one piece of that question, if I understood it correctly, sir, could be answered by the fact that our systems have come up on time and operated as planned and are turning transactions around when they reach our door as the IRS. The other part of the question having to do with ensuring that data safeguards are adequately in place and that we've reassured ourselves as to that point, we'd be glad to arrange a separate briefing to take you through more detail of what that team did. But that team started, as I understand it, very early on in implementation, working with states and the HHS about what would be required, how the design of their systems could take the safeguards into account, and again, on limiting where that data can go and how it has to be walled off and protected. I'm not an expert on all the pieces that they did, but we'd be glad to provide a separate briefing if that would be of help.
Okay, recently it was reported that the Minnesota Exchange accidentally released the names, addresses, and Social Security numbers of over 2,400 brokers. Exchanges will store a significant amount of sensitive data, including income and employment information. If it comes to IRS's attention that an exchange improperly handles sensitive data like Minnesota has done, what steps will the IRS take to ensure sensitive taxpayer data is protected?
Two pieces. One, that because it's restricted from view to so many people that might raise your concern, we think we've greatly reduced the likelihood. But if it comes to our attention, we actually can turn the switch off on the computer within minutes to cut off a feed to a particular recipient if we have reason to think that that recipient doesn't merit the approvals they received previously.
Thank you. I think my time has expired. I yield back.
I thank the gentleman. We now go to the gentlelady from the District of Columbia, who I was with earlier working on the issues of reopening the District of Columbia, and I want to personally thank her for her efforts.
Well, Mr. Chairman, you have stolen my thanks because I wanted to thank you for coming to the swamp site, taking a respite from the hearing, which you, of course, are obligated to chair, and considering that the District of Columbia's local budget, which is fast, where we're fast running out of contingency fund, was important enough to leave a hearing that I know you have shaped, and I very much appreciate that you did. And of course, the chairman, as he spoke and had to leave, so I didn't get a chance to thank him in the manner to which he deserves. Was quick to tell me that the hearing is going on, and I realized I was AWOL. I did want to attend this hearing because the gentleman's question about being adequately prepared goes to my question. Ms. Ingram, you are a senior civil servant of considerable intelligence and long experience. If anything, I have great fears that we will lose people like you as civil servants are going through the issues that now confront all of you. Now, here is a new function. I imagine that you were given this function because of that long record, because of your great ability. We have a major change in the tax code and the tax laws of the United States. In your experience, have you ever seen a change as major as the change that you now confront? Where you have everything from your regulations to your IT infrastructure, new tax forms, that's not unusual, to come forward with?
I think people debate whether this or the Tax Act of 1986 or the 1974 passage of the Employee Retirement Income Security Act, how those would all stack up. Yeah. I will say that this is certainly one of the largest pieces of legislative implementations the IRS has tackled in recent years, but we're confident that we have it organized and we're on track.
Now, with respect to those other two large tax overhauls that you mentioned, were you given increase in funding beyond your normal funding in order to handle the new workload in those two instances?
I will confess I was not employed in 1974, so I don't know what was done then. And in 1986, I was not in a position to know that. So I'm not.
Well, let me note that I have information that between 2010 and 2012, the budget of the IRS was cut by 3%. Now, that's one thing. You would wonder, if you have a major new function on the order of the two you discussed, why cuts would be in order rather than some increase, particularly given concerns, I think quite legitimate concerns that have been raised here about privacy, not to mention difficulty. Let me ask you then. Well, first let me tell you, I happen to be sitting in the Financial Services Appropriation, in the Appropriation Committee when the Financial Services Appropriation went through, and I was just stunned because the Appropriation Committee passed a 24% reduction in the IRS budget for 2014. I need to know, particularly in light of concerns, privacy, and other concerns that have been raised here, whether you will be able to meet your benchmarks, the internal ones that you say have thus far been met, and to afford the protections with a quarter of your budget being cut at a moment when we're seeing one of the most major increases in responsibility ever given the IRS?
Well, I would like to leave the budget discussions to Acting Commissioner Werfel and his budget team, so I'm a little hesitant to opine on the elements that Congresswoman.
But I'm not asking about the elements. I'm just asking whether or not here, I'm speaking as a layman, can an agency which is given a major new responsibility simply move forward, absorb that major responsibility, change the infrastructure, issue new guidance, acquaint all the employees with new IT and regulations? Is that a fair or reasonable mandate to give an agency of the United States government?
Our agency has a great deal on its hands, including the legislative implementation that we're required to do. Tough budgets require tough choices, and folks beyond me will be involved in that choice-making depending on what budget is available at any given time.
You can be assured of this, Ms. Ingram, that your effectiveness in carrying out the ACA and your other responsibilities under the Internal Revenue Code will be scrutinized by this committee and others, and if it does not, notwithstanding whatever the cut is, if you do not meet up to those, none of the blame will be laid here in the Congress of the United States, which instead of increasing your budget to accommodate changes it has mandated, has reduced your budget, making it very difficult, assuming the budget gets out at all, for you to meet the very demands we're making on the agency. And I thank you very much, Mr. Chairman.
I think the gentlelady makes a very good point, which is that if you manage to live with 24% less, we won't call you. If it doesn't work out, undoubtedly somebody will be in front of many committees. We now go to the gentleman from Florida, Mr. DeSantis.
Thank you, Mr. Chairman. Thanks for having this hearing. I'm sure this is going to be a subject that's going to have a recurring importance given the huge expansion of the authority of the IRS under the so-called Affordable Care Act. I heard some of the colleagues on the other side of the aisle almost just mocking the hearing, and it really struck me because it's almost as if somehow we're just not supposed to talk about Obamacare anymore. And I think as we've seen it become implemented, the more and more apparent it's been that the promises that were made to justify the law's passage are essentially null and void. They were essentially false pretenses. I mean, for example, the President said the only change for people with insurance is that you will pay less, and that estimate was $2,500 per family. That, Americans are finding out, is totally not going to be the case. If you like your plan, we were told you can keep your plan, but yet we see stories of spouses losing their coverage, employees losing their employer-based coverage, getting put on the exchanges. And then we said, if you like your doctor, you get to keep your doctor. But if you lose your current plan, you end up on the exchanges, you may not have access to the same doctor that you did before. And so the issue is not going to go away, given that what was promised is not being delivered. I think it's also just interesting to compare the passage of the health care law with some other major pieces of legislation. I just looked this up. It's amazing. Social Security got 96% of Democrats in the House, 81% of Republicans. Eisenhower's interstate highway system got 93% of Democrats in the House, 98% of Republicans. Civil Rights Act 1964, 61% of Democrats in the House and 80% of Republicans in the House. Reaganomics 1981, 78% of Democrats in the Senate supported that, 98% of Republicans. And even welfare reform in 96, broad bipartisan agreement. You didn't have any bipartisan agreement here. And so I think that also contributes to the controversy. I keep hearing that this is the law of the land, as if it's somehow sacrosanct, that you can't actually advance legislative changes to it, and that just, we have the authority to do that. Of course we're able to suggest changes, delays, repeals, whatever is in our Article 1 authority. But the thing about this notion that somehow it's the law, full stop, you can't even talk about it, is if this is such a sacred piece of legislation, then why isn't the President implementing it as written? I mean, we've talked today about the delay in the employer mandate, which was supposed to start in January with no statutory basis for the delay. We know that there was a delay on the cap on out-of-pocket costs, which were supposed to take effect this year. We know subsidies were granted to members of Congress without having a statutory basis. Income verification requirements for exchange subsidies suspended, and then the use of subsidies on these federally-based exchanges. And that's what I want to talk about now, just in terms of whether this implementation is being done with the law. The law under the Affordable Care Act says, Section 1401, subsidies can go to an individual, quote, enrolled in through an exchange established by the State under Section 1311 of the Patient Protection and Affordable Care Act. And of course, we've seen most states have rejected creating exchanges as the law contemplated, and so then the IRS has had to determine, well, what about these federal exchanges? And I don't see any statutory basis for those subsidies to flow to federal exchanges. Nevertheless, on May 23, 2012, the IRS finalized a regulation which actually allows subsidies to flow to federal exchanges, even though there's no provision in the law to allow that. So my question for you is just, were you consulted when they were devising this rule about whether the IRS should issue guidance allowing subsidies to flow to people who were enrolled in federally run exchanges instead of exchanges instituted under Section 1311?
I was present for a number of different topics that were covered by that reg. For that particular topic, I was not particularly involved. I was probably in a briefing or two where other people discussed it, but it wasn't my decision.
So they weren't asking you your thoughts about whether you thought that these subsidies should flow to people in federally run exchanges?
I'm about administrability, not about the legal policy calls.
Now, were you, prior to this regulation being instituted, were you guys going forward with your implementation assuming that the subsidies would be available for the states that declined to create a state exchange?
The proposed regs included the same position, and there were many comments that were filed, as is always the case after proposed regs. It's part of my job to keep track of what's in the proposed reg stage, ask about whether what's coming in comments and the likelihood that something would change so that we don't go too far in implementation steps if something is going to change and we would have to change our work. That's my role.
But so the answer, though, is yes, you guys had assumed that there would be federal subsidies for federally run exchanges?
I kept track of the likelihood that the position in the proposed reg would change so I could adjust, if necessary, the administrative work.
Thank you. Thank you, Mr. Chairman. Yield back.
I thank the gentleman. I think the gentleman brings up a good point, since CBO never scored that subsidy. At this point, we've concluded our first round. I'm going to ask the gentleman from Maryland, the ranking member, to close, and then I'll close.
Thank you very much, Mr. Chairman. Ms. Ingram, I want to take a moment to thank you again for being here. But I want to thank you for something else. I want to thank you for having a can-do attitude. And I really mean that. I'm the son of two former sharecroppers with only a second-grade education each. And one of the things my father used to say to us as kids, and they educated all 7 of their kids on a domestic salary and a laborer. And their attitude was always, there's no such word as can't. I thank you for, first of all, believing that you can get something done, get it done well, and then doing it. And I do believe that you're an exemplar of so many of our federal employees. Many of them are sitting home right now, or wherever they may be, possibly watching this, or they'll watch it later on. And they, too, have those can-do attitudes. And, we hear a lot about the Affordable Care Act. And clearly, they are things that should be done to make it better. I think They tell me when Medicare started, it had a lot of problems and issues. But I think what you have shown is that the piece that was, that you had to deal with, obviously, good planning, targeted dates, I guess, some kind of timetable, making sure the tasks were done, and always saying, I'm going to reach that goal, I'm going to get there. And so I thank you, I really do, for, and you shook your head a little earlier when I said the word on the street was that, you're a superstar. But that's what I've heard. You don't have to shake your head again. But it's the people like you and the people that sit behind you. They give so much. They give so much because you realize it's so much bigger than you. And I look at the people who come to work for us. Most of these folks could be doing something else. But they come, I'm talking about Republican and Democrat. They come to work every day, they believe in what they're doing, and they give everything they've got. And so I know you said that you feel comfortable, you're on target, and I would just ask you to maintain that. And I'm saying this for a reason, because I want people to know that they are appreciated. They really are. They're appreciated for what they do because they are touching millions upon millions of Americans. And a lot of times I'm sure they sit at their desk and say, well, what am I doing this for? Why have I got to go through this? The problems keep coming and whatever. But I do believe that deep in their hearts, people like you, for 31 years, this apparently must feed your soul. It must. And I think that when people have a passion for something, that is where their strength is. And if we, as the public, are beneficiaries of your passion and of your purpose to make this society a better society, and I am convinced that once we work out the kinks in ObamaCare, that we will have something that will benefit society long after we're dead. That, to me, I mean, I can't think of too much more when you think about, looking back at your life, and if someone were to write a book, and for you to be able to say, well, I did my part, I did it well, and I'm not just talking about you, but I'm talking about all the team that are making it happen for IRS and ObamaCare, if they want to call it that. I want to thank you. Thank you, Mr. Chairman.
I thank the gentleman. Quick announcement, I spoke to Acting Commissioner Werfel, and he was not able to get us the documents that we presented to you. Additionally, obviously, well, not obviously, but he stated that, in fact, he wouldn't be able to determine whether you were correct or not correct about that being 6103 documentation. So I'll work out with the committee and the Commissioner how we can go through and get properly redacted material going forward, how we can get the discovery we did not, and we'll try to resolve some of those questions, hopefully without having you back, even though I desperately would like to know the details underneath these communications and others. And from our oversight, it appears as though there are hundreds, if not thousands, of documents that have been claimed to be 6103 that are not. Again, you're not in the redaction business, neither is the Commissioner directly, so we'll work that out with him. I'm going to go through just a couple of short things. You talked about the community. Under the Affordable Care Act, there's a 1% tax going to 2.5% if somebody doesn't buy insurance. And as the President has said, and many have said, that's been held, that law has been to the Supreme Court. But let me just run through the numbers for a moment and ask you, with your experience of working with the community, if this makes sense. Warren Buffett makes a couple of $1 billion in a bad year. So under the Affordable Care Act, as a single individual, his penalty would be in the millions if he did not buy insurance. And yet the required cap for insurance would be less than that. Do you find it interesting that there's no provision in the Affordable Care Act for somebody to self-insure or to, in some other way, meet the financial responsibility, and therefore they are being mandated to buy a profit-oriented insurance package in many cases?
Well, I want to, if I could speak first to the comment about Mr. Buffett, the actual calculation of the tax is capped at what it would cost to go get insurance, so it wouldn't be just simply a multiple of his income. But I'm sorry, I apologize, I was distracted.
Would that be the minimum plan? Because right now they set a minimum in the law, but there's no maximum dollar set. So is that the high deductible $4,200, $5,000, $10,000?
I'm not going to have the exact which premium it is, but it is capped at the cost it would otherwise take someone to go get insurance, and there's a definitional thing in there. I can give you a more precise answer.
Okay, so if Mr. Buffett would have a $10,000,
let's say,
plan that would be the minimum he could have, then he'd be penalized $10,000 taken from him, but he'd get no health care. Is that right?
that would be his economic choice at that point.
So he cannot insure and pay the same amount as for insuring under the law?
I think there is a more sophisticated answer to that, so I would like to be able to respond more fully.
Yeah, no, please respond in writing, because from what we read is if you pay the fine, if you self-insure, you will be charged the amount of having insured. You will have no coverage, but you, in fact, can self-insured. So you can pay all of your own charges, not be covered, and yet pay the same amount as if you were covered. I find that sort of an interesting one. Let me switch to another part. In most of your 31 years of Federal service, I presume, and I'm not trying to be overly personal, but I think it's for 2.1 million workers and 8 million covered, we're in FEHBP. Are you?
Yes, I am.
So you're familiar with the 300 or so choices available, and certainly the 11 plus that are available to you in any of the communities around the District of Columbia. You're in a FEHBP plan, but you've looked at the array of ones available.
I am in a plan through that program, yes.
And does it meet the minimums under the Affordable Care Act requirement for insurance?
My understanding is that it does.
And employees of the House and Senate, including employees of this committee, are in that plan also. Is there any reason, any logical reason, that they should be thrown out of that plan, other than it was mandated in the law?
I haven't been involved in any of the discussions about what should or should not be done about the coverage of folks on the Hill, and I would defer to those people.
Yeah, no, really stupid things done by members of the House and Senate to the employees who work for us probably are something for you to stay out of as long as you get to say an FEHBP. The next question is one that does fall to you. If Congress tomorrow declared that FEHBP was a Federal exchange, would there be any inconsistency with Federal exchanges, small business Federal exchanges such as the D.C. exchange?
I'm not sure what the inconsistency question is. Your question immediately started my brain working on the logistics and the wiring, so I'm sorry, that's where my brain went.
Right, but currently FEHBP covers over 8 million people. It covers COBRA for people who have left the Federal workforce. It covers the vast majority of retired Federal employees, and it covers virtually every current Federal employee and their families. So you have a plan that has over 300 options. You yourself in the district area get dozens and dozens of choices, HMOs, PPOs, conventional. You have a non-age discrimination single price point that you can shop online prior to making your decision. Does it look like an exchange to you when you go into it, or like an exchange you would like to have look?
My particular enrollment has rolled over consistently for so many years. I don't know what the experience is at the moment for new enrollees, so I can't really respond to the extent to which policymakers or this Congress wishes to look across those fact patterns and equate them.
Well, let's just go through. You've been studying the Affordable Care Act and its implementation and the exchanges, so you're familiar with what we're offering. And it doesn't surprise you that Mr. Cummings or I can go online during open enrollment, and we can look through policy after policy, find out how much it costs, and choose.
Okay.
It doesn't surprise you that there's no age discrimination, that 31 years into your career, you pay the same amount as somebody who's starting tomorrow, that it's a flat fee within FEHBP.
I'll take your word for it, sir. I'm not an expert in FEHB.
Well, I'm a little surprised. 3 years working at Affordable Care Act. Let's continue. Doesn't surprise you, though, that FEHBP, you're able to move from plan to plan, and any pre-existing condition is not a problem, right?
That's my understanding.
And I'm taking you through this.
I'm not sure, though, but
It's true.
okay.
Take Trey Gowdy and my word for these things.
Okay.
So it's portable as long as you're within the Federal workforce. There's no age discrimination. It doesn't care about pre-existing conditions, and you have huge amount of different choices, HMOs, PPOs, and conventional, and you can be covered by 96% of all doctors in America and in all 50 states. In your opinion, if all that be true, is there any reason that the health care plan that you have, that I have, that the President and Vice President and every member of the Cabinet are eligible for, shouldn't be made available to the American people?
That's a policy choice that I leave to people in policy positions.
If you were not in the Federal workforce, would you like access to the program you're in now? Or would you like to go to an exchange?
I would want to understand my options at the exchange at a personal level, depending on where I lived.
But is there any exchange that has as many choices as FEHBP or even close?
I'm not familiar with the array of choices in the various exchanges. That's HHS. I'm not sure what question you're asking me, sir.
I'm just asking you for the common sense of, since FEHBP doesn't have age discrimination, meets all the requirements that were anticipated in the Affordable Care Act, why the President and members of Congress in the House and Senate never opened up the plan they were in. In fact, the President has more choices than any exchange in America. So people being forced into the exchanges, Federal exchanges, including my staff and Mr. Cummings' staff, will be given less choice than FEHBP. I'd hope you'd be able to answer that. But let me just review one thing that I heard here today, because I think it's important. The IRS is ready. They met their deadlines. They were timely. And in fact, there are no known flaws in the IRS's performance as of today.
True.
So we need to get Secretary Sebelius in here, because basically HHS has screwed this whole thing up. The delays, the inability to get on, all of that comes out of HHS. It's not your end of the business.
That's not the part that we've been working on, no.
Okay. Does it surprise you that if you go online, you deliver your Social Security number as you're required to do in order to get a calculation and look at plans, and then you decide not to accept any of the plans and you go to exit because they've made you give your Social Security number, they've looked up your database, your tax information, and they have your email. They send you back an email telling you how much you're going to have to pay if you don't sign up for the Affordable Care Act?
I'm not familiar with the way they've sequenced their enrollment process, other than I know that some of our folks have looked carefully at the questions that are asked to ensure that any tax-related items are correct and to ensure that no tax data is displayed on the face of the machine.
I just find it interesting that they use your taxpayer database, even if somebody might have insurance and they're just looking at what the exchange would be because they don't know whether they'll have insurance. They go through the process of in order to check for a hypothetical enrollment, they give that information. They then get an email basically threatening them with the fine if they don't sign up. That's just an observation of people who were signing up, who are calling our offices and saying, I didn't know I'd be told how much I'd have to pay if I didn't enroll.
The only time that we are sent a query is when somebody has gotten to a point in whatever exchange it is to say, I would like to learn about possible assistance. The way in which those questions are sequenced may not be uniform across exchanges, but we do not receive a query for every person entering those websites, only if they decide they would like to learn about their assistance options.
Can you imagine, you had this question earlier, did you ever get a complaint by somebody who got a tax credit? Did you ever find somebody that didn't want their taxes reduced or eliminated? Can you imagine anyone not checking to see, hey, can I get a subsidy? That's going to be almost universally asked by virtually everybody that goes online is, am I eligible for a tax credit or a subsidy? It's human nature. I think we established that earlier. Don't you agree?
I think that's their economic interest or curiosity. They are told that for the income information, the queries will include asking us about their tax data. If they don't wish to check that box at that point, they can make that choice.
Well, Ms. Ingram, here's the good news. You have literally been saved by the bell. We have run out of inquiries. You've been very generous with your time. We will make every effort to not have you have to come back over the items that you've offered for the record and the items that we were not able to read. And with that, again, I thank you for your 31 years of service, and we stand adjourned.